Alright, hi guys, and thank you for tuning into another new video. Alright, so in this one I'll be covering intellectual property rights. Now, I was kind of like browsing through and trying to find some great like legal topics to it for you guys, and I literally was like going for like a list of like maybe like I would say like maybe 5 to 10 topics, and ended up totaling with around like I would say maybe 30 to 40 topics. So I started like working on notes breakdowns for a few of them. I will be adding a second video covering custodial and non-custodial parental rights and procedures. That way I can kind of like finish tying up the last little few tad bits of my notes for that one, as well as a new topic that I was kind of, reintroduced to by the help of my mother. She was like, check out prop 1 and then add that one into that one. And I was like, alright, I'll definitely have to like check that out. And then in doing the research into it, I was like, oh, okay, now I see what you said that one may fit into the parameter. And she was like, yeah, do some more research into it and then see how you can kind of like tie it together with that. And I was like, well, it's going to be a great one to cover actually. It will tie into the rights of the parent and the right to your own body, and overall kind of set an aspect for both parents and their rights within the situation, and choosing to continue or end a pregnancy. So that one's going to be interesting. I'm going to add into the final snippet also. I will tie together my final like note section, so I believe the next video will probably like total to around like maybe 20 minutes or so at the max. But in this video we're going to touch base on intellectual property rights. Now for the introduction breakdown, I'm literally going to go through the overview of it. So for this one I literally got a bunch of great facts and definitions and statements to literally tie the entire like process together. So luckily I'm going to be able to actually read through my notes this time as like kind of like a script, and then I'll provide breakdowns and more information pertaining towards the information that's stated. That way it's kind of more in the plain English sense. So to start out, intellectual property IP rights protect creation of the mind. So in creating any type of, let's see, artwork, or should I say art interpretation, if you create a song, if you create an art piece, inspired by your mindset that you can possibly create and bring to fruition, the right protects your ownership of said property, and there are a bunch of different standards that are included in this. And while reading through, you guys are going to literally go, okay, I definitely know what you're talking about, and then in ever hearing any of these topics brought up, you'll literally have the insight required to literally know what the heck is going on, how everything is tied together, and what are the rights that pertain towards these set standards and the time frames for the protectorates. It allows creators to benefit from their work. The World Intellectual Property Organization, WIPO, identifies IP protected in law by, for example, patents, copyrights, and trademarks. As you guys each know, you've seen copyright symbols placed next to brand names. You've seen trademarks marked, noted, and represented through the media, such as news updates. Let's see. Anyone actually kind of like referencing towards like trademarks also. And patents, as you know, are the protectorates that you set when you release a product to the public. You patent the idea to protect it as a product that you own. It is your product that you have the protectorates to literally kind of set the basis for your ownership that is protected by law. The main purpose of IPR is to encourage and reward creativity, protecting your creative interpretations, protecting your ideas, your projects, your products, and your brand is the protectorate involved in IPs. Intellectual property rights, IPR, refers to the legal rights given to the inventor or creator to protect his invention or creation for a certain period of time. As noted before, there are time constraints for each different type of protectorate that you are granted. These legal rights confer an executive right to the inventor/creator or his assignee to fully utilize his invention/creation for a given period of time. A patent is the granting of a property right by a sovereign authority to an inventor. This grant provides the inventor exclusive rights to the patented process, design, or invention. So you are protecting not only your product, not only the design that you've created, you're also gaining the protectorate for the invention overall, and you gain these exclusive rights to protect your product and your idea overall for a designated period in exchange for a comprehensive disclosure of the invention. So in filing for a patent, you are filing for the protectorate of your product and or idea, and you also are granting the public access to all information pertaining towards your product, service, or invention. So I love science. Follow someone on YouTube, subscribe to the channel. Their name is, I'll blank out the first part. I don't know if you're able to mention people on here without it being a big deal. So I'll just say blank Nile, and he does really great videos and content. And in doing so, for a lot of the products that he wants to check out and replicate and create, he often refers to patents, and the patents include the formulas required for the products that he would like to literally experiment with, create. In doing so, he's able to break down a bunch of chemical compositions and recreate the products that are referred to in the patents because the formulas are provided to the public. Now, this is going to be a keynote because it's going to kind of reference to another topic later that is within the IP family, but it involves the protection of the formula. They're a form of incorporeal rights. Ownership of a patent gives the patent owner the right to exclude others from making, using, offering for sale, selling, or importing into the United States the invention claimed in the patent. 35U.S.C. And now we'll go into copyrights. So copyright protects the original expression of creative works such as literary, dramatic, musical, and artistic works. Literary works include novels, poems, essays, articles, blogs, and compilations. Dramatic works include plays, operas, and musicals. Musical works include songs, musical notes, and lyrics. Artistic works include paintings, sculptures, photographs, prints, art, reproductions, maps, and diagrams. Sound recordings include music on CDs, podcasts, and recorded speeches. Motion pictures and other audio-visual works include movies, commercials, online videos, television shows, and video games. Architectural works include building or other architectural plans, such as, the ideal blueprints and building plans, resource allocations. I would say resource allocation methods, but that's kind of me referencing more towards my public administration freaking studies. But overall, blueprints and the plans for designing any type of architectural or building project. Copyright protects the way these works are expressed, but not the ideas, facts, systems, or methods of operation. This principle is sometimes called the idea expression dichotomy. Copyright protection begins when an original work is fixed in a tangible form, such as writing down ideas on a paper or typing them on a computer. So it having a actual copy of what you seek to be copywritten. You are creating a literal, digital, or physical copy and breakdown of the, the plan, idea, concept, or written piece that you wish to protect from being reused without your right or consent. You can register your work with the U.S. Copyright Office for additional benefits, such as access to federal courts if your work is infringed upon, meaning if there is any infringement upon your artistic representation, your work, your ideas, and anything that falls within the parameters of your copywritten works, you can legally take somebody to court, as you guys have heard through many media stories in which copywritten rights were violated. And as for a lot of people that have ever freaking added like a song from a musical artist, you have freaking learned over the years, as I have also, that copywritten material can be blocked. In a lot of cases, your videos can be monetized to compensate the creator for their work, and in other cases, it can be blocked in certain countries due to the copyright protectorates. In brief history of the IP rights. The laws and administrative procedures relating to IPR have their roots in Europe. The trend of granting patents started in the 14th century in comparison to the European countries. In some matters, England was technologically advanced and used to attract artisans from elsewhere on special terms. The first known copyrights appeared in Italy. Venice can be considered the cradle of IP systems, as most legal thinking in this area was done here. Laws and systems were made here for the first time in the world, and other countries followed in due course. Patent Act in India is more than 150 years old. It has been a process that has been ingrained within our society for literally like a century and a few years also. So like a century and a half for India. And the inaugural one is the 1856 Act, which is based on the British patent system, and it was provided the patent term of 14 years, followed by numerous acts and amendments. So it's stated with the 100 years and then a tad bit also. The 1856 Act, let's see, that would be nearly 200 years old. So it's a tad older than the Indian Patent Act, but falls within the parameters of still being an act that is still less than 200 years old. But as stated before, a century and a tad more also to kind of set the basis for the belief to protect the rights of the individual and their intellectual property rights overall. Properties and their descriptions include: originally, only patent, trademarks, and industrial designs were protected as industrial property, but now the term intellectual property has a much wider meaning. IPR enhances technology advancements in the following ways. It provides a mechanism of handling infringement, piracy, and unauthorized use. It provides a pool of information to the general public, since all forms of IP are published except in case of, and this is the one that I told you about, the superfund that protects recipes and anything that is wished to be kept a secret, but still should be protected by law, trade secrets. Now, before I add a ton more details pertaining towards patents, copyrights, and let's see, trademarks, I'm going to touch base a tad on trade secrets because that one having to be a fun one. While doing a bit of research, I gained some great insight on something that you guys will definitely know about and that you'll kind of go like, oh, well, that's interesting. I kind of freaking wondered. So with companies like Coca-Cola, as you guys noticed, that's one of like the most major leading like cola companies. There's the freaking Coca-Cola line of products that work within the framework that is the Cola franchise as well as the Pepsi franchise. Coca-Cola is protected by the trade secret, right? Now, in doing so, a lot of people kind of question, why would you not patent the formula? And in doing so, the plan was to keep the formula for Coca-Cola kept safe within a vault and overall ensure that the protected secret would remain a secret. Patents to protect the secret formula. Ultimately, the decision by Coca-Cola to not patent their product was the right one. It's been over a century and the secret recipe is still not out to the public. Like that's like one of these amazing freaking aspects of it. There are so many companies that make their own cola variations and I feel as though a lot of people can still freaking reference to the love for the Coca-Cola taste and the brand overall. And in doing so, it kind of adds to the added aspect of that secret, give it that added aspect of tasting even more like yummy and interesting. Coca-Cola, you'll literally just kind of think to yourself, what is the freaking secret? What makes this so yummy that I kind of just want another one or that I kind of just want to finish this can? Like, what makes it so freaking just taste different from any other cola? I feel like when you taste most other colas, you taste it and you get that freaking like ideal cola vibe. And when you taste the Coca-Cola, it's just like, it's yummy, it's sweet, it's freaking savory, and it's like, it quenches your freaking thirst. Now, from what I've learned over the years, it's stated that soda is simply known to kind of like dehydrate you more due to the freaking like sugar components of it. But when you have a drink that's just so freaking yummy, it just making you feel as though you I tend to do. It usually takes me like a decent bit to drink like a soda, so I typically throw it in like a water bottle that has like a sealed cap on it. That way I can keep the carbonation within the freaking drink and then just kind of enjoy it throughout the day. For Coca-Cola, which is locked in a vault, is an example of a trade secret that is a formula or recipe. Since it has not been patented, it has never been revealed. The New York Times bestseller list is an example of a process trade secret also. The term intellectual property IP is sometimes used as something separate from intellectual property rights. IPR, in such cases, the term IP means the abstract product of the intellect, and the term IPR refers to the legal right covering IP. So, in having anything that can be protected under the rights of intellectual property or that falls within the parameters of an abstract product or creation of the mind, overall interpretation, that would fall within the category of intellectual property, and the rights protecting your intellectual property and your creation, your idea, and your product would fall within to the category of intellectual property rights because you now have the rights to protect your intellectual idea, creation, and now protected interpretation of, or should I say, your protected final freaking product that has been released to the public. Scroll back up a tad bit and cover patents, and then I'm going to conclude the video with a breakdown covering corporate espionage as it pertains towards. I was actually going to do a separate video for it, but in reading the freaking breakdown, I was like, this is going to actually pertain more towards this topic. So I was going to cross off the third topic for the day and literally do like three freaking like note sections for three separate videos. And I was like, I'm gonna have to just include this one and this one because it literally pertains towards like the freaking intellectual property and corporate freaking guidelines. Industrial designs relates to features of any shape, configuration, surface pattern, composition of lines and colors applied to an article, whether 2D, e.g. textile, or 3D, example being such as a toothbrush. To any mark, name, or logo under which trade is conducted for any product or service and by which the manufacturer or the service provider is identified. Trademarks can be bought, sold, and licensed. Trademark has no existence apart from the goodwill of the product or service it symbolizes and is said to be protected upon. Relates to expression of ideas in material form and includes literary, musical, dramatic, artistic, cinematography work, audio tapes, and computer software. Are geographical indications are indications which identify as good as originating in the territory of a country or a region or locality in that territory where a given quality, reputation, or other characteristic of the goods is essentially attributable to its geographical origin. So geographical indicators help to set the basis for a product or service that is offered by a company within a set geographic ordinance. Now this one was a fun one. This one pertains towards intellectual property rights in India again. What are the different types of intellectual property rights in India? In India, there are 7 types of intellectual property rights, namely copyright, trademarks, patents. Copyright, trademarks, patents, geographical indications, plant varieties, industrial designs, and semiconductor integrated circuit layout designs. So, as stated before, design plans, industrial design setups, plant varieties are protected by freaking people that are able to literally like create their own freaking like type of freaking plant and then overall have the major basis for what they grow and sell. It protects their rights to said plant variety. Geographical indications that are set within a geographical ordinance. Patents, as we have also that it's been broken down as the protection of the intellectual property rights of configuration, service pattern, composition of lines, and right by a sovereign authority to an inventor that grants the exclusive rights to the patented process, design, or invention for a designated period in exchange for the comprehensive disclosure of the invention to the public. Trademarks was like touched base upon, but I don't have the breakdown pertaining towards that one. But we do have copyrights, and the guidelines for copyright pertains towards the protections of original expressions of creative works such as literary, dramatic, musical, and artistic works, as well as architectural works also, which I would kind of just state like as something. It's still like artistic interpretation and the, of course, intellectual freaking to be protected. And I feel like that one kind of like you have to freaking add in that freaking like stated in the freaking breakdown the architectural freaking like ambiance for it to like show that representation of it, but it still is an artistic representation. Mega projection. There are four main types of intellectual property rights, including patents, trademarks, copyrights, and trade secrets. Patents and trade secrets are both ways to protect inventors, but they differ in how they work and what they protect. Protections include a patent gives the owner the exclusive right to make, sell, or import the invention for a set period of time, usually up to 20 years. A trade secret protects information that remains secret, such as a formula, process, or a method. Disclosure. To get a patent, the inventor must disclose their invention to the public through a patent application. So if you ever check out patents online, the intellectual notion that is being offered to the public, and in doing so, you gain access to formulas, the guidelines, anything overall, and the parameters, the caution freaking notions, and all of the freaking notes from the inventors. Trade secrets are protected without registration, and the owner must take reasonable steps to keep their information secret, such as vaulting the Coca-Cola formula. Enforcement. Enforcing a patent can be expensive, but it's usually more achievable than enforcing a trade secret. So, in having your product protected by a patent, it allows for you to literally kind of just like go, well, that product seems interesting, but you know, they're kind of just making something similar to mine, as opposed to another product that is being disclosed and protected by the patented rights that has your exact same formula. That product can then literally be for the freaking infringement upon your intellectual property rights. Such situations, in a trade secret misappropriation case, the owner can recover damages for the actual loss and unjust enrichment. So, in doing so, if somebody infringes upon your trade secret and happens to find your secret formula, such as if somebody happened to freaking like find the vaulted freaking Coca-Cola formula, or if an employee happened to leak the formula to the public, that would be an infringement upon the company's trade secret, and in doing so, Coca-Cola would have the right to sue for the damages lost due to their formula being leaked to the public. In a patent infringement case, the owner can only seek a permanent injunction to stop the infringement. So you can seek a permanent infringement to stop any further actions that would infringe upon your intellectual rights being imposed upon and being look at us doing great. This one's only like freaking 30 minutes. I'll probably be able to finish this in like just this. Yep, this is like the final section. So, corporate espionage, also known as industrial espionage, is the act of stealing a company's proprietary information, trade secrets, or intellectual property to gain a competitive advantage. The goal is to use the stolen information for financial and commercial gain. So, in doing so, you seek to infringe upon the rights of the company in the hopes of making a freaking. So, you're also risking and all that you will ever have. So it's never something to really just kind of like dabble in for the fun of it, or to even attempt. Corporate espionage include trade secret theft, stealing sensitive information, and about existing or developing products. Client information theft, stealing client data, including financial information, to lure clients to a competitor. So, stealing client information and then using it to kind of like poach the clients from one company over to yours. It's also an infringement upon another corporation. Trade secret theft would be an infringement upon intellectual property rights. Financial information theft, stealing financial data to offer better deals to clients and partners, win bids, or make better offers to employees. So, attempting to poach them by offering them a competitive rate as opposed to your competitor is also something that would fall within the category of corporate espionage. The attempt to add a competitive edge that will kind of like sabotage another company and lead to, again, you poaching their employees for your own personal gain. Marketing information theft, stealing marketing information to prepare a timely response to a competitor's marketing campaign. So, let's say McDonald's releases like a new burger, and Burger King and Wendy's each release like the exact same burger. The first like team to introduce that new product to the public will be the one that is overly affected by attempt and basis to watch what your competitors are doing to steal their idea and then market against it with the same product at a different rate. So let's say McDonald's freaking launched a new burger and it's just so big and so yummy that they freaking market up for like $7 per burger. It's just that freaking yummy. It's just that much of a formula that you're gonna want it. And then their competitors see it over at Burger King and they're like, we're gonna do that too. And we're gonna make this super freaking yummy. We're gonna make it just as freaking big. We're gonna make it juicier. And we're gonna make it something that you can buy for a cheaper freaking rate. And we'll offer you a meal, and our meal will total to the rate that you would have gotten that burger from McDonald's for. And then it's like, no freaking way. And then Wendy's sees this and they're like, well, you know, we have our never frozen beef, so we can do this even better. So let's say we release a burger and we freaking introduce it as something that's never frozen, and we also freaking, you know, beat Burger King to the punchline and offer a freaking fully vegetarian freaking alternative to the freaking burger, and we offer it for the same rate as Burger King, but throw in something extra to sweeten the deal. Let's say instead of freaking offering burgers, or fries, and a drink, Wendy's decides to go 4 for $4, but even larger, and they offer you the freaking burger, that new freaking yummy burger that everybody's talking about, that everybody's freaking making a new version of after McDonald's freaking announcement. You get a freaking 4 to 6 piece chicken nugget with it, depending on how generous they're feeling and how freaking ready they're ready to go. We've got those. And then they throw in like a medium freaking fry or a large fry, depending on how big you want that meal. And then they throw in that freaking drink to sweeten the deal also. Oh gosh. And then all for the same rate as Burger King, but you get more. So then it adds that freaking edge for it, where you're like, do I want to go get that burger from McDonald's, but then I won't get a meal? Like, and if I do get a meal, I'm gonna have to pay like $10 for it. Or do I want to go to Burger King and then get the freaking like burger and the meal for like $2 less than McDonald's, and literally I just got the entire freaking thing that McDonald's was gonna offer me for $2 cheaper? Or do I want to go to Wendy's and get the exact same freaking meal for like $2.50 cheaper, plus I get chicken nuggets? And then it's like marketing freaking information theft to the damn max. That competitive edge to literally beat out your competitors and offer the deal that's going to literally make them think, do I want to go with that one? Because I did it first and I love that restaurant. Like, I'm a big fan and I always go there, and I would really love to try it there because I saw it and I was like, I definitely want to go there. But then they're selling it too, and they're selling it for a different rate, and I do love that place too. Or that one where I love that place too, and they're offering way more, and it's like cheaper than the other two. So it's like kind of like working through the snag of like, which one will the consumers want after that, and how set to react to retaliate towards the espionage of each that followed after the announcement. To prevent corporate Espionage. Companies can train employees on the risks of corporate espionage and how it can impact the business, markets, and employees' careers. Create a workplace culture that encourages employees to be responsible and cybersecurity aware. So protecting your information and the information of the company, and being sure to not share any information that should really be protected will not only protect you but your company as well. And then in doing so, it creates a secure place to work and a future where you are not only represented by the brand, but you are also representing the brand as somebody who has a mindset geared towards, solidarity. And then for the final note, before ending this video, working to establish and implement proper security procedures. So setting a basis and creating contracts that include all parameters should be protected, and the rights of employees as well as the rights of the company that our employees are set to uphold and protect. That way, as stated before, our jobs, our companies, and our jobs, our companies, us and our employees, we are each all secure, safe, and preserved and protected against corporate espionage. And in doing so, we create a progression and a mindset geared towards preventing any of the bad things that could possibly ever take place. Alright, thanks so much for tuning in, you guys. I will be popping in with some new videos in just a few days, and I hope you guys get a chance to check out the first video. For any of our parents out there that are going through custody battles or that know anybody that may be going through custody battles, I once again some insight pertaining towards custodial and non-custodial parental rights and procedures, as well as the rights pertaining towards child support and anything that also falls within that parameter. I did an entire freaking hour-long video a bunch of freaking aspects pertaining towards the subject, so go ahead and go check those out. It can be found on our YouTube account. You can literally get all the insight and info that you need, and I will be linking the sources to find all the information, to back the information stated throughout the video. That way you can do some more extensive research during your own time. There are currently two versions of it. There's the original version of the video that went up and the second version of the video where I increased the volume of it, because I literally ended up listening to it and I was like, this is a tad too low, and I want to make sure you can hear me and gain all the information that you need. Be sure to check out our social media pages, such as our X account, which is DKHLegalAid, our TikTok account, DKH.legal.aid, our Instagram, DKHLegalAid, and stay up to date on any updates pertaining towards our company and all updates pertaining towards new videos, new products, and what's going on over at DKH, and my personal freaking life updates, of course. I love you guys, and I will talk to you later. Have an awesome day.